I have no idea.
Yeah, you can.
Hello, is it on? Good morning, everyone, once again.
All rise. The African Court on Human and People's Rights is now in session in the matter between Rema Lawyer for Human Rights and the Republic of Rema. Justice Honorable Madonsela presiding. You can be seated.
Good morning. Welcome to the 30th African Human Rights Moot Court competition, sitting at Stellenbosch University, South Africa. In the matter before the court, is the matter between Rema Lawyers for Human Rights and the Republic of Rema. Can we please firstly have the applicant team introduce the team members and confirm the allocation of time. Thank you.
Thank you very much, Presiding Judge, and good morning to Honorable Justices. The applicant team will be composed of the first counsel. My name is Martin Kioko Munyoto. I will be addressing the court in the first 12 minutes with respect to the question of jurisdiction and admissibility. Then the second counsel, Daniel Kulibali, will address the court in the subsequent 11 minutes and will be dealing with issue A on gender-based violence. The third counsel will be Counsel Sydney Tambasi Netia, who will address the court with respect to issue C, the rights of sexual minorities. Then lastly, we'll have the fourth counsel, will address the court for 12 minutes with respect to issue B on the rights of children. We humbly reserve 2 minutes for rebuttals. Thank you.
Thank you, counsel. May we have counsel for the respondent?
As it pleases the court, I will be first counsel for the respondents. I'm Ms. Ruiz. I will be dealing with all the procedural issues. Second counsel is Ms. Maharaj. She will be dealing with the issues of gender-based violence. Third counsel is Ms. Pasaru. She will be dealing with the rights of children. And our final counsel for the respondents is Mr. Diamau, and he will be dealing with issue C, namely gender identity and sexual orientation rights, and we will each be using 12 minutes. Thank you.
Thank you. I just omitted one very important detail, which is to quickly introduce the bench, if I may. Just be indulged to quickly introduce my colleagues. Oh God. Right, I just remembered that I'm not wearing my glasses May I ask, even though it's unusual procedure, but I'm going to ask my brothers and sisters to just quickly introduce themselves. Starting with you, sir.
Thank you very much, Madam Chair. My name is Angelo Matus. I'm a former judge of the African Court on Human and People's Rights. My nationality is Mozambican, and it's a great pleasure to sit in this bench. Thank you very much.
Bonjour à tous. Mon nom est Laurence Purgor-Marcel. Je suis professeur à l'Université Paris 1 en
I'm professor at the University of Paris. I will start over. My name is Laurence Baudouin-Larsen. I am a professor at the University of Paris Sorbonne, and I was a member of the Constitutional Court for 8 years. Thank you.
Robert Nanima. I'm a member of the African Committee of Experts on the Rights and Welfare of the Child, and I'm also a national from Uganda. It's an honor to be presiding here today. Thank you.
Thank you, sir.
Thank you, Chairwoman. My name is Solomon Ayele Derso. I'm currently the chairperson of the African Commission on Human and People's Rights, the Banjul Commission. I'm an Ethiopian and alumni of the Center for Human Rights as well. Good to be here.
Thank you to my honorable brothers and sisters. Counsel for the applicants, may we please have the first counsel present your case, sir. Thank you.
Presiding Judge, Honorable Justices, and the delegation from the Unitary Republic of Rima. Good morning, and may it please this Honorable Court. My name is Martin Kioko Munyoto, and I appear as the first counsel for the applicant, Rima Lawyers for Human Rights. I will be addressing the court on the preliminary issues of jurisdiction and admissibility. Honorable Justices, 1 in every 4 women and 1 in every 3 members of the LGBTQI community in Rima experience gender-based violence. Rima being a heteronormative and patriarchal society, less than 10% of these survivors ever get to report their cases. In this highly polarized society, laws such as the Criminal Offences Act, the Births and Deaths Registration Act, and the Children's Act aggravate the situation by fueling the fire. On the one hand, the Criminal Offences Act criminalizes consensual sex between adults and insists on the regulation on the mode of dressing. On the other hand, the Children's Act allows for child marriage, while the BDR Act insists on a binary gender identity for children as either male or female. These laws, Honorable Justices, evidence entrenched neglect and discrimination as against women, children, and sexual minorities. For example, the child Anjij is denied access to education. The child Mpo is sexually exploited. Women such as Maria are murdered, while sexual minorities like Caroline experience violence in the streets of Rima. It is in light of these circumstances, therefore, Honorable Justices, that what we shall be establishing before the court is not for you to grant any new rights, not for you to impose any new obligations, but for this court to affirm the rights already protected in the African Charter and the treaties ratified by the respondent. I will begin now with our submissions. On the preliminary issues of jurisdiction, it is the applicant's submission this court is vested with jurisdiction. The jurisdiction of this court is established under Article 3, Subarticle 1 of the Protocol to the African Charter on Human and People's Rights for the establishment of an African Court on Human and People's Rights, which we shall subsequently refer to as the African Court Protocol, or simply the Protocol. The interpretation of which was made in the case of Konate versus Burkina Faso by this court in 2014 at paragraph 30, where this court said that it must preliminarily ascertain that it is vested with the 4 attributes of jurisdiction, namely material, personal, temporal, and territorial jurisdiction. It is the applicant's submission that the court is vested with all these 4 attributes, but will proceed further to argue on the basis of personal jurisdiction, which appears to be in contention. The contention, Honorable Justices, on personal jurisdiction is centered around the withdrawal of the applicant's observer status on the 1st of April 2021, as evident under paragraph 11 of the facts of the case. The combined provisions of Article 5, Subarticle 3, as well as Article 34, Subarticle 6 of the African Court Protocol reveal that only non-governmental organizations enjoying observer status with the African Commission can institute cases before this court. In light of this, therefore, considering that the applicant, at the time of the institution of these proceedings, had observer status, then the court is properly clothed with personal jurisdiction. The question, therefore, that arises is whether this withdrawal of the observer status affects the pending case before the court. Our answer to this is the negative. This withdrawal does not affect the jurisdiction of the court. We place reliance on the principle of non-retroactivity as espoused by this court in the case of Umuhoza versus Rwanda at paragraph 68 in 2016, where this court, although it was interrogating a question of the withdrawal of the Article 34.6 declaration, held that such a withdrawal has no effect on a pending case. As Professor Frans Viljoen argues in his book, International Human Rights in Africa, at paragraph 256, the rationale for this notice period is to allow for juridical security, to prevent the abrupt suspension of human rights, especially for victims who've already been affected. And therefore, in this respect, we urge that the court holds that it is properly vested with personal jurisdiction since there were already acquired rights after the matter was instituted.
May I ask a question, Counsel? The case you've just cited is a case that deals with withdrawal of the country's signature on a treaty. But the case you are arguing before us is about withdrawal of the status of your organization from a seat in the African Court, in the African Commission, or rather, not a seat, but observer status. How do you translate that into the rights of the applicants you are representing?
Thank you for the question. And indeed, I agree with you that it is unfortunate that the court has not had occasion to interrogate a question of the withdrawal of the observer status. We therefore invite the court to allow us to guide you through these uncharted waters. And we ask the court to borrow the interpretation of the principle of non-retroactivity as applied there. And the rationale being that in the case of a withdrawal that has no notice, then there is an abrupt suspension of the rights of the victims. In this case, therefore, since the case had already been instituted, denying the court had already invoked its personal jurisdiction. Taking that away at this point would not be in the interest of the victims who cry before this court today. If that answers your question, I will quickly move to the admissibility requirements.
I will be speaking Portuguese. Maybe you switch on the.
Okay.
Yeah. Então.
When I was trying to justify the principle of no relativity, I referred the case, a practical case decided on this court. I referred to an article written by Professor Viljoen. My issue here is, what is the relevance of that case? What relevance has that article written by Professor Viljoen to, let us say, so that this court must decide on a very concrete issue? That is what I need to understand. Thank you.
The article book by Professor Franz Viljoen that I quote was actually quoted verbatim and with approval in the case of Umuhoza versus Rwanda at paragraph 62 of the ruling on jurisdiction issued on the 5th of December 2016. And it's therefore on that basis that the book was relied upon in the case that you quoted before Your Excellencies this morning. Turning to the admissibility requirements.
If I may come in, I just wanted to understand, under Article 5.3 and 34.6 of the protocol, you yourself indicated that the basis for your organization to appear before this court is the possession of observer status with the African Commission on Human and People's Rights. So the moment that observer status is withdrawn, the legal basis for you to stand before this court also disappears, doesn't it?
In response to that, the personal jurisdiction of the court is seized at the time of the institution of proceedings. This is as held in the first ever decision by the court in the case of Michelot Yegogombaye versus Senegal at paragraph 39. And therefore, in reliance on this authority, we espouse that this court had already been seized of its personal jurisdiction and therefore proceeds as such. Seeing that I have 3 minutes, could I proceed to the admissibility requirements?
Just one last question through you. What's the legal basis that you're using under the protocol to ask this court to draw on inspiration from other sources?
Thank you, Honorable Justice. Article 60 of the African Charter asks the court to draw inspiration from the African human rights system, from the international human rights system, from the United Nations human rights system. It is on this basis, therefore, that we rely also on the past jurisprudence of the court and other instruments. Turning now to the admissibility requirements of this court as set out in Article 6, Sub-Article 2 of the African Court Protocol, Article 56 of the African Charter enumerates 7 requirements for admissibility. However, in the interest of time, we'll be arguing on the need to exhaust domestic remedies as captured in Article 56, Sub-Article 5 of the African Charter. Honorable Justices, while the obligation to exhaust domestic remedies is golden, it is not cast in stone. This is to mean that as the African Commission elucidated over 2 decades ago, in the case of Jawara versus the Gambia, the exhaustion of domestic remedies only happens if the remedies can be seen to be available, effective, and sufficient, failure to which an applicant can request to be excused under the exceptions of exhaustion of domestic remedies. In this respect, therefore, the applicant submits that on the 3 issues before the court, we are excused from exhausting domestic remedies. I will begin with the first issue, which is issue 1 in relation to gender-based violence. We advance the argument that since gender-based violence is a criminal matter, as established by the CEDAW Committee General Recommendation number 35 at paragraph 26.c, that in criminal matters, the onus is on the state to investigate and carry out prosecution. And this was also espoused by the African Commission at paragraph 72 in the judgment of Article 19 versus Eritrea in 2007. Therefore, in this case, the respondent had the obligation to investigate and prosecute. And since this is a criminal matter, then the complainant cannot be expected to exhaust the domestic remedies. With respect to the second issue, which is on the rights of children, the case of sexual exploitation as against Mpo is also of a criminal nature, and therefore the obligation is on the state to investigate and prosecute. I will make the last submission, which is regarding the pending complaint before the CEDAW committee. 30 seconds. Thank you for your grace. Regarding the pending committee, the applicant relies on the express reading of Article 56, Sub-Article 7 of the African Charter, which denies admissibility of complaints which have already been settled by another international tribunal. And since the matter is not settled, we urge the court to hold that the matters are admissible. I will now invite the second counsel for the applicant. Thank you very much.
Dear Madam, honourable members of the African Court on Human Rights and People's Rights, please receive our greetings, our most respectful greetings. We would like to talk here about gender-based violence in Rema. With regard to Article 1 of the Protocol of the Bill on Gender and Development, it gender-based violence judicially contains all of aspects which is performed on people, which engages or which produces emotional, physical and corporal damage. This young girl of 17 years old is more than a real case who is the victim of gender-based violence, because the violence perpetrated against us, which removed the violence of the scene, which also removed all of the consideration in her physical capacity. In reality, to have refused to spend a night with Rolfinho because she was tired, and which caused him to be unhappy, to be satisfied in his sexual needs. In fact, honourable judges, we would like to apologize for the words that will now follow, but it will be needed to be expressed on how Rolfinho treated her like a slut, as a street woman. And according to the African Commission in the Egyptian case, and we will not be surprised indeed, and that you would have taken part in this decision. These words are only used in the context of a woman. And this makes us believe that the Professor Heyns had presented this scene when he defined this treatment, and I would like to quote here, the treatment that are used to humiliate the victim, to debase her, to refuse her any kind of personal consideration of herself. Distinguished judges, if these words, insults, seem to be terrible, then I would not be surprised, because they were in fact the start of a deluge of violence. He beat her, he struck her in the face, which made her lose 3 teeth and also broke her jaw. So, with regard to all of these facts, in the African Commission gives us the perfect answer, because she herself admitted.
Egyptian initiative case, but I'm struggling to find the relevance of that particular authority with regard to what you're saying. Could you give us some clarity on how it would apply? I'll repeat. You refer to the Egyptian case, Egyptian Initiative for Personal Rights, but you haven't built the connection with the facts that you're giving us. Could you give us some clarity on the relevance of that case to the facts you're giving us?
So, in the Egyptian initiative case, which was rendered by the African Commission in 2006, it was indeed about a woman who had been the victim of the same kinds of words that were used by Rolfinho, and it's the same words that were repeated. and that appeared as well in this case. So that the court esteemed, therefore, that, no, rather the Commission felt that there had been gender-based violence because of the words that are only used for women. And it is on the basis of this decision of the Commission that we also believe that these words that Rolfinho is using with regard to impor are words that are some kind of form of gender-based violence against impor. So, with regard to these facts, the Commission, the African Commission,
how does the fact that Refilio used this word get attributed to the responsibility of the state? He is a private citizen. It doesn't have anything to do with the state, as far as we are concerned.
Paragraph 4 of the factual report shows us that there is no provision in the Criminal Offences Act. So that means that the state of Rima is committing, is not meeting its requirements or to pronounce on the use of these words, because all of the instruments that are ratified by the state of Rima, the protocol of Maputo, the African Charter of Human Rights and People's Rights, should be. So to take some legislative measures to protect citizens, like should be, so in Serac and Nigeria, which is the case, and the National Commission of Freedoms, this commission retained that the responsibility of a state can be relied upon when the state is showing that it is not upholding the protection of the rights of its citizens, and when it does not take any measures, legislative measures, to protect the citizens against any prejudicial attacks. So the Inter-American Court as well gives us this example with regard to the state of Rima. So in Velasquez and Rodriguez, which is another case in Honduras, the European Court, the Inter-American Court of the Human Rights, said that if a state allows a group of people to act freely with impunity to the detriment of the rights that are recognized, then in fact it is in violation of its international obligations. Sorry, Councillor, can we consider that this Velasquez Rodriguez, in fact, relate here because it has to do with forced disappearances, which is may not be pertinent here, or it is in fact. It's with regard to the application here by the state of Rima to honor its obligations, and the same reasoning that we can also hold here, even it's about Velasquez and Rodriguez, and it deals with forced disappearances. The court, the Inter-American Court, held that because Honduras showed that it was lax, it did not protect its citizens sufficiently against forced disappearances, then the state has omitted or failed to uphold its obligations, and therefore the declaration or statement on these disappearances was neglected. So the state should be taking all of its measures to protect its citizens, and the state of Rima also ratified these legal instruments, which imposes an obligation on it, including the SADC protocol, where it should be taking legislative measures, steps, and by 2015 to protect the citizens against gender-based violence. But the state of Rima does not take it or does not understand it like that, because until today, 2021, the state of Rima in the Criminal Offences Act, there is not a single provision that can sanction any gender-based violence act. So can you see, honourable judges, that the state of Rima is in perfect contradiction between its international obligations and the application of these obligations in its state. Excuse me, sir.
That the Criminal Offences Act doesn't have provisions to give protection, but the Criminal Offence Act prohibits rape, battery, and assault. Wouldn't this be the basis for giving protection to women?
In fact, it is an omission in the state of REMA. Why only use the provisions that deal with rape when the state of REMA can also take specific dispositions and measures to better protect women and children and their rights to protect them from violence? Why does the state of REMA does not do it? Simply because it is lax, it is failing to protect the rights of the women and the children. And in fact, this is also demonstrated that all the women that were victims of gender-based violence and that have seen many of their complaints suspended. Are there any statistics in the report that can support what you're saying? With regard to the state of Maria, in fact, no investigation was carried out with regard to its gender-based violence that she was a victim of, the sexual violence. Simona as well had to beg the health services to be received and to be examined, to be treated, to prove the sexual violence that she had suffered. And it should the state of REMA is saying that they should be using material evidence to support their case. However, they do not make available any means to help them present the proof, for example, the evidence. For example, there was no proof in the hospital where these women went. So the state of REMA is neglecting to protect its women. Madame la Présidente, est-ce que je...
Indulgence for 30 seconds.
Acho pertinente, por isso mesmo que não obstante.
I think it is very important, and although your time is really up, I think I would like to ask you a question, because one of your requests is that the state of REMA approve legislation on gender violence. We notice, however, that the state of REMA has in fact got a constitutional court. And we could consider this legislative mission and this constitutional court, I believe, would have amongst its responsibilities certainly to make a judgment, for example, in the case of an omission. So before you came to this court, don't you think that you should perhaps have gone to the Constitutional Court of REMA to, in fact, hear a judgment and to see the constitutionality given the lack of legislation in REMA in terms of gender-based violence?
A whole minute, and I'm using my discretion for differentiated treatment because your time has been eaten by translation.
Okay. Merci, Madame.
Thank you very much, Madam. Given that you have, I thank you for that, your kindness to give me an extra minute. Thank you, and I'm going to answer the judge with, based on paragraph 36 of the communication of Serac versus Nigeria, and we quote, "When a right is not really provided for, there cannot be any efficient there can't be a remedy." This means that in REMA, for example, given that there is no specific legislation regarding gender-based violence, no competence, no court, in fact, can efficiently prosecute gender-based violence and of a citizen of the state of REMA.
Can't you then take the Criminal Act to the Constitutional Council for review for being insufficiently compliant with international obligations?
In the factual report, it is cited that the NGO, Human Rights, turned towards the provincial court of the state of Rema for that court decides on the constitutionality of Article 82. And in fact, these articles were at the basis of the gender-based violence of which Caroline was a victim. However, the tribunal, the court of the state of Rema, highlighted that in terms of physical abuse, in fact, did not concern or relate to human rights. And it shows here that the police, that the health services and the legal services of Rema authorities are in fact failing to guarantee the protection of the rights of people, especially with regard to gender-based violence. Thank you very much, Madam President.
We're going to have the third representative of the applicants. Over to you, sir.
Patriarchy, public opinion, the morality of the majority, and the hegemony of heteronormativity cannot surely, honorable justices, be acceptable justifications for a state to breach its international human rights obligations. Judge President, honorable justices, good morning. As introduced, my name is Sydney Tambasi Netia, third counsel appearing for the applicant, and I will address the rights of sexual minorities in a threefold manner. First, I intend to demonstrate before this honorable court that sexual minorities are indeed protected under the African Human Rights Framework. Secondly, to demonstrate that Section 182 of the Criminal Offences Act is a violation of the right to freedom from non-discrimination. And lastly, to make the argument that the Birth and Deaths Registration Act is a violation of the right to privacy. If there are no interjections, I will straight away proceed to the first limb of argument. On the very outset, honorable justices, we understand that Article 2 of the African Charter does not make this express recognition of sexual minorities as a protected group. However, through the works of the African Commission, starting with the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe, decided in the year 2006 under paragraph 169, the Commission indeed recognized that Article 2, in protecting against non-discrimination and providing for equal protection before the law, does recognize that sexual orientation can be protected under the ambit of sex on the grounds listed in Article 2. Honorable Justices, the Commission did not stop there. It has continued to take concerted, calculated steps towards the protection of both sexual orientation and gender identity. We recognize this, for instance, through the principles and guidelines on economic, social, and cultural rights under paragraph 1D, where sexual orientation is recognized. It is culminated in the resolution 275, where the Commission makes an express recognition of now not only sexual orientation, but also gender identity. And this is also reiterated in the General Comment number 4 of 2017, where the list of the grounds of non-discrimination includes both sexual orientation and gender identity. Honorable Justices, the danger of not making this recognition was in fact found in the case of Legal Resources Foundation versus Zambia in 2001 under paragraph 163, that lack of giving effect to Article 2 of the African Charter in essence would deny victims of violation, would deny peoples of Africa protection of other human rights protected in the Charter. Now, when we look at the fact pattern in paragraph 27, for instance, we find that by failing to give this recognition to Caroline, then she is exposed and suffers certain violations such as the right to her physical health, which is protected under Article 16 of the African Charter. And therefore, Honorable Justices, it has been a long wait for sexual minorities, at least to have their case decided on the merits stage before this court. The time is now.
You've eloquently cited what I would call soft law, and none of what you've cited amounts to hard law and enforceable instruments. So what's the basis for us accepting that it is obligatory for this court to regard those principles as binding, or the recognition of identity right and rights that transcend heteronormalcy as human rights?
Thank you, Judge President. Indeed, the authorities have made heavy reliance on a soft law. The very first point I would begin is Article 45 of the African Charter, which grants the African Commission the mandate to develop these laws in response to the development of human rights law in Africa. That while the drafters of the African Charter did not envision this protection in the Charter, this does not mean that the African system should be stuck in a historical point of view, but that through the developments, for instance, of judicial precedent.
But we're not the African Commission.
Apologies, Madam President. I would then rely on the complementarity doctrine that is under Article 1 of the protocol establishing the court, that while the African Commission on the one hand makes progress with respect to the right to certain rights, in this case specifically sexual minorities, then as the court you hold the rope on the other side and help the African Commission towards this recognition. In essence, Honorable Justice, we understand that there has been no decision on the merit stage with respect to sexual minorities, but our submission as the applicants is that the time is now. While we missed our opportunity in 2015, when you could not decide the CAL advisory opinion on the merits, we submit that this is then the time for sexual minorities to receive their protection under the African Court protection regime.
Cher Conseil, nous ne sommes pas...
Dear, we are not legislators, we are not drafters. Do you not think that this would go beyond our jurisdiction, in fact, if this is the argument you are proposing?
Thank you, Justice Loren. I understand your concern. Perhaps to answer your question, we do submit that as of yet, while there is no hard law instrument protecting against the rights of sexual minorities, the African Charter, Justice Loren, is a charter of people's rights. It is a charter that guarantees every person's rights. And therefore, if sexual minorities, if we would go back to our clients and tell them that in fact, you have been told that being part of this social grouping, you do not get protection under the African court, they would start to wonder then, what is the definition of people's rights? But more specifically, I will make reliance on the case of Attorney General versus Ramoge before the Botswana High Court, where the interpretation of the Botswana Constitution's equivalent of Article 2 of the Charter made the recognition that the word every person should be inclusive in terms of its interpretative and not narrow, to the effect that despite your membership to social grouping, despite your sexual orientation, despite your gender identity, then you should be protected under this ambit of every person. We know them by their names. Caroline is a person. Anjij is a person.
If I may come in, Council, the authorities that you cited from the side of the work of the African Commission on Human and People's Rights, they are directed at providing protection from violence. I don't know how that would extend to a positive obligation on the state to give recognition to identity. So if you could explain how we start from a principle of non-discrimination and a principle of protection from violence to a requirement that obliges the state to give recognition to identity of social groups.
Thank you, Dr. Solomon. To answer your question, we understand that when this identity is not recognized, as for instance was seen in Botswana in the case of ND versus Botswana, then in effect, other rights are violated by lack of this identity. I have given the example of Caroline, that because she is not recognized, thank you, that because she is not recognized as a transgender person, then her right to physical health is violated when she's beaten in the street. Anjij, because the child is not recognized as an non-binary, then his right to education is violated. And these are protected rights within the African human rights framework.
So you are saying that these protections couldn't at all be afforded without giving recognition to their identity. Is that what you are saying?
In essence, yes, relying on the facts.
Not at all.
Sorry?
It couldn't at all be possible to give protection to these rights, to these other rights, without giving recognition of identity.
In this case, the answer is yes, because the kind of violation of their rights suffered under the fact pattern is due to this lack of identity. Honorable Justices, having made the submissions for the applicants, we thank you for your hospitality and your time, and therefore I invite Council Kome to make our concluding arguments. Thank you very much.
Merci, Madame.
Thank you, Madam Chair. Madam Chair, honorable members of the African Tribunal for People and Human Rights, please accept our honorable greetings. My name is Kwame, and I will speak on the issue of child rights. First, we will demonstrate that Mpo was a victim of sexual exploitation and she was deprived of her right to education, in addition to the violation of the principle of the best interest of the child. According to Article 27 of the African Charter on the Rights and Welfare of the Child, and also Article 34 or the Convention on the Rights of the Child, state parties must take all necessary measures to protect children against any form of sexual exploitation. UNICEF defines sexual exploitation as the abuse or attempted abuse of a position of vulnerability or trust for sexual purposes. And according to the WHO, the mere fact of having sexual relations with a child is tantamount to sexual exploitation. In this specific case, Rolfinho, an adult, has been having since 2016 sexual relations with a child, Mpo, a minor, only aged 17. And he took advantage of her vulnerability and the trust that she bestowed onto him. Honorable judges, you will agree with us that this is a clear case of sexual exploitation. And of course, the other party will attempt to contest this mere fact by questioning the relationship between Rolfinho and Poe to demonstrate that it was not sexual exploitation. Honorable judges, their arguments may not hold ground.
Counsel, why should we take the definition by UNICEF? Aren't there other definitions of sexual exploitation? And as you engage that question, is sexual exploitation synonymous with sexual abuse, or the two are different? I think clarity on that matter would help us going forward.
Honorable Judge, we referred to the UNICEF definition because this is the authority in the protection of child rights. And according to Article 60 and 61 of the African Charter on the Rights and Welfare of the Child, we felt that it was useful to refer to UNICEF definition to prove that Mpo was a victim of sexual exploitation by Rolfinho. And the arguments, looking at the minimum age for marriage, in terms of the relationship between Rolfinho and Poe, there might be a confusion in the sense that it may be presented as a marriage, but we must add that that minimum age is set at 18 years old, and this was held by your court. But in the case of ADDF versus Mali, where the court found that Mali will have to set the minimum age to 18 years old for marriage. Madam Counsel, we have the state of Rema, the Republic of Rema, which in reference to Article 21 of the Protocol of Maputo, because Rema had some reservations according to that article. Will that still hold grounds? Our argument is based on Article 27 of the African Charter on the Rights and Welfare of the Child. Regarding the Maputo Protocol, reservation may only be valid according to the Vienna Convention. It must not infringe on the main purpose of the treaty itself. Looking at the Vienna Convention as well as the Maputo Protocol, the reservation, the objection by RIMA is a violation of the purpose of this treaty. Of course, the other party will attempt to give you the impression that the SADC protocol in Article 8 authorizes marriage before the age of 18, and also the REMA law on minority, which authorizes the marriage of minors from age 16. But honorable judges, according to the SADC protocol, such a marriage may only be validated if it is for the welfare and the best interest of the child. And in this specific case, looking at at the physical abuse that Mpo was a victim of, there is no doubt that this relationship was not in her best interest. You will then agree with me that based on what I have exposed here, sexual exploitation took place and Mpo was a victim of that count. So.
You've alluded to the SADC protocol, which talks about marriages of children being allowed if it's in the welfare of that child. Is that still your position? How do you reconcile that to the position of the African Charter on the rights and welfare of the child in terms of the added value it gives to protection of the child from child marriages?
Honorable Judge, of course, validating a marriage with a child of less than 18-year-old would be validating early marriage as in the case APDDH and HIRDA. As I mentioned earlier, you asked the state of Mali to modify, to amend its law in order to set the minimum age of marriage to 18 years. And this was a recommendation by the Committee on the Rights of the Child in its general observations on the health and development of the child. The rule that you are mentioning concerns Mali, and how is REMA obliged to comply with an order which was targeted at Mali. Honorable Judge, there is a responsibility to implement the Charter, and a decision which is imposed on a specific state may also apply to another state party in this convention. Honorable judges, the state of Rema is party to the Charter and therefore must comply with all decisions taken by the court, and that includes protecting the rights of the child. So this child, who is supposed to be the main priority for state, is excluded from the priorities of the state of Rema. And of course, in addition to Mpo, Anjij, a child aged only 6, was deprived of her right to education, as well as a victim of its best interest violation. Sorry.
Criança, muito bem. Socorre-se do protocolo de Maputo. No translation? Yeah.
It's solved. We can restart.
French?
Yes, we do. You may restart. Can you restart, please? Thank you. I was saying that in your argument, you rely on the African Charter on the rights and welfare of the child, claro, and then you mentioned the protocol of Maputo. I'm worried when you ask this court to recognize the violation of the children's rights, when you mention Article 24 of the United Nations Convention on the Rights of the Child. Aren't you asking this court to recognize a violation which is not of the competence of this court? Are you not talking about a violation which is included in the Convention of the United Nations on the Rights of the Child, which is not an African instrument?
Thank you, Honorable Judge, for your question. It is clearly stated in Article 3 of Article 3 of the African Protocol, establishing the African Court. It is clearly stated that the African Court has a jurisdiction on all matters related to the interpretation of the African Charter, as well as other instruments that are relevant and related to human rights. By instruments, we mean a specific matter related to human rights where the defending state is involved. And out of paragraph 4 of the fact stated, REMA ratified the International Convention on Children's Rights. And honorable judges, you will then agree with me that you have there the solid basis that enables you to acknowledge the disposition or the provisions of these charter. Article 3 of the African Charter. Madam Chair, may I have your microphone, please? Madam Chair. Merci.
I would suggest that you also address us on your take on the case of Anjiji. And specifically, I would like to know whether there's ever a justification. Is it your argument that a child should never, ever be taken away from parents under any circumstances?
Madame la Présidente.
Madam Chair, Article 19 of the African Charter on the rights and welfare of the child imposes on the state party to protect children from separation with their family. And out of the decision held given by the African committee of experts on the welfare of child on the case of minority rights and SOS Esclave versus the state of Mauritania, it was held that every decision made regarding the child must be made on the basis of their best interest. And best interest, according to the High Commission for Refugees, equates to the welfare of the child. So nothing proves that Anjij being put in a home it's in her best interest in comparison to life with her family. So of course it was also established that her parents did not spare any efforts to guarantee her rights to education and all other rights. Especially the right to housing, adequate housing. But all these efforts were fruitless due to the fact that the state of Rema acted against the best interest of the child, and that rendered all efforts put by the Anjij parents fruitless. Therefore, Anjij being put in a home is an infringement of her best interest. Therefore, Madam Chair, honorable members of the court, we may conclude then that we have a mix of feelings. We are very sad looking at the situation of these children which are abused and sexually exploited and taken from their family, as well as being deprived of education. And we also feel anger when looking at the fact that the Republic of Rema introduced in its criminal act physical corporal punishment and refuses to prosecute crimes. And also we feel that, Madam Chair, these actions will not remain unpunished by this august court. Thank you very much, Madam Chair.
We are now going to listen to counsel for the respondents. Counsel, please take your place and present your argument.
As it pleases the court, I, Ms. Ruiz, and along with my learned co-counsels, we will be representing the respondents in the matter at hand. The African Charter protects the freedoms of people living in states who have ratified the Charter and places an obligation on these states to balance the interests of all those living within its society. And this balance must be struck by taking into account the generality of international law and then modifying and applying it to the specific social and cultural contexts of a state. I will be dealing with the procedural issues of jurisdiction and admissibility, and my learned co-counsels will approach this honourable court and deal with issues A, B, and C respectively. I will be looking at jurisdiction, specifically the applicant's contention that this court does have the necessary personal jurisdiction to adjudicate upon this matter, as well as admissibility, specifically that the applicant has failed to exhaust all local remedies, rendering this application inadmissible before this honourable court. And lastly, I will look at any previous settlement of any aspect of this matter. The applicants have submitted that this court does have the necessary personal jurisdiction. It is, however, the respondent's submission that the applicant lacks the necessary locus standi to appear before this honourable court, rendering this court without the requisite personal jurisdiction to adjudicate upon this matter. In terms of Rule 39(1)(f) and 5(3) of the protocol, an NGO may indeed bring a case against a respondent state who has deposited the necessary declaration before this honourable court. And in accordance with Rule 41(3), an NGO may only appear before this court if they have the necessary observer status. However, upon the African Union's request, the Commission withdrew the applicant's observer status in April 2021. This court must take into account its own advisory opinion for request of the advisory opinion by University of Pretoria.
Counsel, before
Yes,
you
Justice.
proceed, you mentioned that the African Commission withdrew the observer status in April 2021. But this case was filed with the Commission in 2020. So there is a significant time difference. And I don't see how those specific rules of procedure of the court would have relevance in this particular instance.
Thank you, Justice, for your question. In that regard, the respondents have 4 submissions. The first is that in coalition, it was held that an applicant who is an NGO will only have the requisite locus standi if they have the necessary observer status to appear before this court. And that is at the time that the matter is to be heard. The second response to your Justice's question is that in other cases heard by both the Commission and the court, when applicant themselves withdraws a complaint.
Before you proceed further, you said that they have to have this observer status at the time appearing before the court. Where is the authority for that?
Can you please rephrase the question, Justice?
What is the authority for saying that they have to have observer status when they are appearing before this court instead of at the time of the application of the case?
Thank you, Justice, for your question. It is our contention that in terms of Article 3(2), the word submit does not mean, and I will give authority, Justice, now in terms of this argument, that the word submit is not when the case has been filed before the court, but rather at the date upon which the matter is to be heard. And in this instance, this was in July of 2021 initially, and now in September 2021, we are appearing before this Honourable Court. In previous matters before both the Commission and the Court, specifically Paul versus Sudan, for instance, which was heard by the Commission this year in 2021, when applicant withdraws the necessary...
Excusez-moi, conseillère. S'agissant de cette...
Excuse me, on that issue raised by my honorable colleague, what can you tell us on international practices on this specific matter? Because the argument that you are raising does not seem to comply with international rules on the issue of introduction of the request, introduction of the case.
The answer to this is by looking at previous cases before the Commission and the Court. And when applicant themselves have withdrawn a case and withdrawn their complaint, the Court and the Commission have not been obliged ever to hear that matter once the case is to be heard. So for instance, if a matter was filed in January and the matter was to be heard in December, if, for instance, an applicant withdraws their complaint in July, the court will still give a judgment in December whereby they say there was a complaint, the complaint has been withdrawn, there is no judgment on this matter. It is our submission that there is therefore an interim period wherein applicants can remove their application, and as well as the fact that in that time withdrawal of observer status can also occur, because the date upon which observer status is required is upon when the court is to adjudicate upon this matter, i.e. the 25th of September.
But in this case, the substantive matter presented to this court hadn't been withdrawn. The substantive matter still stands. Besides the withdrawal of a case, I don't know how that argument would have any logical resonance with the decision of the Commission withdrawing the observer status of the applicant here.
Thank you, Justice, for your question. It is our submission that an NGO can only appear before this court if they have the necessary observer status afforded to them by the Commission. It is our submission, we do recognize that this court does have inherent jurisdiction, so that where jurisdiction is contentious, the court itself does have the power, in terms of Article 3.2 of the Charter, to decide whether or not it will hear the matter. It is, however, our submission that because it is the Commission who grants NGOs the necessary observer status and the necessary locus standi to appear before this court does not have the powers to override the withdrawal of observer status, and because observer status has been removed, this court cannot claim to have jurisdiction in terms of Article 3.2 of the Charter.
Counsel, ainda sobre esta questão, queria saber se...
I want to know if you are familiar with the jurisprudence of this court, and also the issue of the removal of the observer status. This is a situation that is relatively different from the one we have here. But after what my colleague asked you, how can you demonstrate the harmony between what the principles are that where the decisions were based, including the removal of observer states, with what you are presenting here now?
Could the Justice please rephrase the question?
Yeah, I believe you are aware of the jurisprudence of this court with regard to withdrawal of the declaration, right, under Article 34.6. The issue that you are putting forward now is slightly different because it's not on the declaration. My question is, given the arguments that you are putting forward, how can you establish harmony between your arguments now, because the issues are similar, with the arguments that the court based its decision in the cases of withdrawal of the declaration?
Thank you, Justice, for your question. In that regard, this is the first time that the court has been approached in an instance where withdrawal of observer status has occurred. There is no jurisprudence by this court where we can definitively say that there's a certain approach to the withdrawal of observer status and how that ought to be handled. We therefore submit that the court now has a very important decision, as this sets precedent for future cases regarding the withdrawal of observer status. We therefore ask the court very carefully to consider the dates upon which observer status was removed and our submissions that the applicant lacks the necessary observer status.
But if this is your argument, then the court would decide this specific issue on a clean slate. Now the question would be, what is, for example, what are the principles or the considerations on which you are making this submission for the court to decline the applicant standing before this court?
Thank you, Justice, for your question. In that response, we once again would submit that they don't have the observer status. And the legal principles which the applicant used in that regard was the principle of retroactivity. And we submit that that is not applicable here because the observer status was not removed by REMA itself. It was removed upon the request of the African Union. REMA has not barred an NGO from appearing before this court. REMA is still of the view that NGOs, if they have the necessary observer status, can do so. So, for instance, an alternative would have been for the individuals represented by the applicant to have found an NGO that does have observer status to appear before this court.
Excusez-moi, conseillère. Est-ce que je dois comprendre? Est-ce que nous...
So, counsel, what should we then conclude that this court is subject to or is influenced by the decision made by the African Commission, African Union?
Thank you, Justice, for your question. In that regard, the cases of the Commission must be taken into account due to the principle of complementarity. So in that regard, it is not necessarily authoritative, but it is persuasive. Due to time constraints, I will quickly move on to the exhaustion of local remedies and previous settlement of the matter. Article 56 of the Charter regulates the admissibility of an applicant's case. It is the respondent's submission that the applicant has not exhausted all local remedies. The first reason is that the applicant represents individuals who are not impeded from approaching domestic remedies and judicial courts within the state of REMA. Those individuals had the opportunity but chose not to do so. This is in relation to Simona and both Maria, who's... May I please just finish my last submission, Justice? Thank you. They could have approached the courts, but they did not. And in the case of Caroline, she could have asked for a judicial review of the prosecutor's decision not to appeal. Finally, in regards to previous settlement of the matter, in terms of Article 56(7) of the African Charter, it is submitted that a previous settlement of Mpho's case has occurred, and this is in line with the case of Moot versus Côte d'Ivoire, where it was held that the crux of previous settlement of a matter is whether or not another international institution is legally mandated to hear that matter. And in this regard, the CEDAW committee has been legally mandated. Thank you, Justices. I will now hand over to my learned colleague.
Judge President, Justices, in as far as the people of REMA consider tradition and culture to be diametrically opposed to gender and sexual minority rights recognition, there can never be an effective and applicable law that sufficiently protects the most vulnerable individuals in REMA. And that's what forms the basis of our substantive argument before this court. We respectfully wish that the court grant the state of REMA a degree of flexibility and discretion in implementing and enacting their international international law obligations. It is on this basis that our substantive case has two thrusts. The first, that permeates issues A, B, and C, is that there have been no factual violations of any international law obligations. And secondly, should the court disagree, we ask the court to view these violations, or rather to view these obligations, as enacted with a degree of flexibility and discretion in line with the state's margin of appreciation. We will therefore be submitting three arguments. The first is that the respondent state has enacted sufficient legislative and other measures to guard against gender-based violence. The second is that there have been no contravention to the rights of children. And the last is that no identity rights or other rights have been unjustly infringed by the Criminal Offences Act and the Births and Deaths Registration Act. As it pleases.
Before you proceed, can you clarify to this court why we should consider this so-called principle of margin of appreciation? What is the authority for us to take that into account? And also, if you could tell us, what is the scope of this flexibility that you are seeking? How far does it go in terms of the obligation that arise from human rights?
Respectfully, Justice, the margin of appreciation is a doctrine that affords the states a discretion in how to implement and enact their international obligations. It says that the state is the actor that is best suited to understand the social realities on the ground and therefore enact adequate legislative measures to respond to those social realities. In an African context, it has been used before by the Commission in Prince versus the Republic of South Africa. I draw the court's attention to paragraph 51 of that case, where the Commission held that states are best disposed in adopting national rules and policies as they have direct and continuous knowledge of the needs and resources of a state, and are therefore best suited to balance individual interests as well as competing interests in a way that gives due attention and due accordance to international obligations. In as far as the scope of this flexibility requested by the court, we respectfully draw the court's attention to Article 62 of the Charter, which allows every 2 years for a review of any legislative and other measures enacted. We therefore ask for an additional 2 years where we can strengthen legislative and other measures to guard against gender-based violence over and above the existing measures that we do have.
Excuse me, counsel, but you had the 2 years and you didn't do this. We have a dead woman. We have one that has been brutalized and can't, or her ear is damaged. We have a gender reassigned person who has been brutalized. We have a child who has been taken away from home. And all that has happened, all of this has happened without you changing the legislation or the implementation of existing legislation.
Respectfully, Justice, that moves me nicely onto our first submission, which is that the Criminal Offences Act already criminalizes the most egregious manifestations of gender-based violence. That is to say, murder, rape, battery, and assault are already criminalized, and therefore the individual cases of Maria, Simone, Impor, and Caroline may have been taken up in the judicial system existing within REMA.
I apologize, counsel. Is it your argument that there's no specificity to gender-based violence?
Respectfully, we submit that the most egregious forms of gender-based violence are already criminalized. And secondly, our submission is that more gender-specific legislation is already being enacted. The Domestic Violence Bill has been passed by Parliament. It is waiting.
Sorry to keep interrupting. Are you suggesting that child abuse and child marriage is not egregious?
Respectfully, Justice, that falls within the scope of issue B, where my learner co-counsel will address that. Regarding gender-based violence, however, and the specificity of legislation, we already have enacted legislation, or at least passed legislation through Parliament that is simply waiting review by the President. The reason for the necessity of flexibility is because of the widespread protests and backlash that we've seen from conservative groups in relation to this.
Council, 2 points. One is, I wonder if you are suggesting that because of the opinion of the public, that the protection of fundamental rights of citizens depends on public opinion. First. Second point, I think flexibility with specific reference to the essence of the rights and freedoms protected. Does it apply to that point of the essence? So on matters of dignity, on matters of the protection of the physical security of the person, on matters of the life of a person, how does flexibility apply at all?
Thank you for your question, Justice. Respectfully, we have seen the state of REMA in their executive already recognize that dignity, equality, and life matter. That's why in the year 2019, the President did in fact recognize the rights of homosexuals. That's why the Attorney General did stop the arrest of them. And therefore, what we ask the court to consider is that it is not about what the state thinks, but rather how individuals on the ground accept these ideas and norms. Our submission, therefore, is that firstly, there has been...
Excusez-moi, Madame la Conseillère.
Beg your pardon, sorry, Council. You are therefore busy suggesting that the governments and parliaments and states can only take into consideration the point of view of people who are part of the society. But what type of point of view? Because then the death centers in certain countries would never have been abolished in some countries. So if you could already respond to that. And then secondly, you are invoking the theory of the margin of appreciation with regard to the process. In fact, I think you are incorrectly invoking this, and it only appears when the states, when a law is adopted, need to restrict the law, the rights. So, and it is in that context, in fact. So, what you counter argument in what I've just mentioned?
Respectfully, Justice, it is not our submission that in every instance of public opinion should we listen to the masses. It is rather that according to Article 27.2 of the Charter, that rights may be justifiably limited in 4 instances. Firstly, in view of morality, secondly, security, thirdly, communal interest, and fourthly, collective security. With relation to communal interest, we have to see communal interest as the aggregation of all views of people in the country, taking into account vulnerable minority groups such as women. Given that, it is not that we are pandering to public opinion, but rather that we need more time, specifically in a context like REMA, which is patriarchal and heteronormative, which needs more time to socialize out of these ideas in order to enact legislation that people will follow. If we do not have this, the law is not able to harmonize with the social realities of people, and we will see more insidious forms of violence proliferate. Regarding the Justice's second question, as to the applicability of the margin of appreciation, we respectfully submit that we did, in fact, apply the margin of appreciation as it relates to CEDAW, and we said that in as far as CEDAW contradicts or offends the internal domestic laws within this country, it will not be applied. But further, what we would argue is that the margin of appreciation applies more universally. As we have seen that the European Court has held time and time again, it relates to the universality of the state's duty to enact international obligations at a domestic level. Given the generality of international law, we have to make it applicable and vernacularize the broad general scope of international law in a specific context, such as cultural norms.
Madame la Conseillère, si je vous...
if I've heard you correctly, so you invoked it, the Article 2, but are we really limited by this caveat where it in fact contrary to the object of the treaty?
Respectfully, even if the court were to find this reservation invalid, we are still not bound by any legal ramifications that the state does not consent to. It is a principle and a doctrine within international law that states are only bound by consent. And therefore, what we ask the court is for a degree of flexibility in allowing for us to meet the full realization of gender-specific rights. And therefore, as it pleases the court, we conclude that the Criminal Offences Act has already...
Sorry, before you conclude, I would love to hear your views on how you realign the concept of margin of appreciation and the use of due diligence, because you've referred a lot to jurisprudence from the CEDAW committee, and we know that it's heavy on due diligence. Could you address this court on those two? How do you align those two? Thank you.
Respectfully, Council has not applied our minds to the concept and how to harmonize due diligence and margin of appreciation. However, if we were to harmonize them, we would argue that there is no direct contradiction between the rights and interests of all people. The actual contention is how to best give effect to competing rights and interests. In light of this, we have to look at... Yes, Justice.
The competing rights and interests are not clear. From what you are saying, a number of things. One, even when those who have been brutalized and victimized approach the relevant authorities, they have not been provided with the opportunity to present their case and to have their case heard in courts. The institutions of REMA have not been doing what they are supposed to do. Second, the question of gender specificity remains standing, in that you can't equate a killing of a person as a result of, for example, robbery, and a killing of a woman on account of her identity of being a woman. The two are separate.
Counsel, you have 30 seconds.
Respectfully, Justice, we do not think that it is the law's job, as our learned counsel for the applicants have said, to criminalize things like speech that is derogatory towards women. We do not think that it is the law's job to dictate the social views of society. We think, rather, that the state should invest in empowering in institutions such as the police in terms of cultural sensitivity training and other reforms. However, that is not to say that we have not had enacted and implemented legislation that can already cover these instances. And therefore, our submission is we are happy to reform and strengthen these institutions, but they are existing, and therefore we have met the minimum threshold for enactment of legislative and other measures for protection. As it pleases the court, I will hand over to my co-counsel.
Good afternoon. Good afternoon. I am here to represent the Republic of Rima, and I would like to speak to alleged violations of children's rights in the case of Mpo and Heyns. I will, in fact, present the following points. In terms of Mpo, we're going to talk about the alleged sexual violation and the non-existence of marriage, and also at Ginji, I will talk about education and family. Where Mpo is concerned, it is very strange, the communication we received in the terms that the state is supposed to have violated and didn't protect her against sexual orientation, because I don't think we are discussing here whether there was or not sexual exploitation. Did the state or not fail to protect Mpo from sexual exploitation? Because we believe that this prerequisite is not here, because the state created a child law, and in Article 5 5, it criminalizes the crime of sexual exploitation and determines, in fact, the measures of how it should be sanctioned and establishes, in fact, a measure for compensation where compensation is concerned. So I don't think there are any. So in fact, I don't think there are enough reasons here to say that the state failed to protect Mpo, because the state has in fact created all administrative measures and judicial measures for Mpo to have her question settled. So we actually believe that, as the lawyers of human rights have said, that it was Filno who supposedly, in fact, perpetrated this act. So we would like to say that this case is being debated in the courts of Rima.
The administrative and judicial measures that you have taken as a state.
Where judicial questions are concerned, administrative questions, we can say that Rima, being a state which is organized and has in fact the separation and independence of powers, we have judicial powers, legislative powers, and administrative and executive powers. Within those powers, we can say that we have courts, and where Mpo is concerned, she presented a complaint to the court, but in fact, Mpo, unfortunately, this in fact was taken to an appeal court, and we feel that we are still talking about an alleged violation because it's a case that is still being debated. We still do not have a decision. There is not a single decision yet amongst those courts, because we feel that she still had the second option. She could still present an appeal at the Supreme Court or any other judicial organ, for example, as the administrative organization of Rima proves. We have created laws and we do sanction this kind of crime. And administrative, where administrative sanctions are concerned, or laws, we can say that we have hospitals, we have other institutions where that after she was assaulted, she was taken to hospital. She was given all necessary care for her to be able to recover. The doctor, in fact, gave her the best treatment possible within the possibility of the state. And concerning early marriage or child marriage, we also thought it was very strange that we mentioned marriage here, because marriage in Rima can only be done with 3 conditions. We find ourselves here, we are not in fact really here viewing a marriage, because marriage in Rima is only allowed for those above 18 years of age. We're talking about a minor. For her to actually be married in an exceptional circumstances, she should have had the consent of her father, which she didn't get. She did not get the consent. The father was totally opposed to that situation. And since he was a member of Parliament of Rima, he knows the laws. He knows the laws. So he, being that person who decided as a man and a person in his position, and since he knows what the laws of Rima, he knew that there was the possibility within the constitution of Rima to, in fact, be able to have recourse to this if his daughter had found herself in the situation of marriage, and in fact she never got there. In terms of Anjij,
early marriages, have you addressed your mind to Article 21 of the African Charter that speaks to protection of children from harmful practices? Would you maintain your submission after looking at that article of the African Charter on the Rights and Welfare of the Child?
If I do an evaluation of that article, which you have just quoted in terms of cultural practices, it's important to say that as a rule in Rima, the minimum age for marriage is 18. the fact that we have established an exception that was in the sense that in very, very exceptional cases, for very exceptional conditions, we demand that for those who are under 18 and above 16, that with the express consent of their parents, they can enter into marriage. We feel that parents are the best to be able to help us identify whether this serves the best interest of the child, how to best protect the child, and to always show her the best way. So we feel that if the father did not give his consent, or any parent who does not consent to this marriage, I think we can see that this article being an exception, I don't think that the lawyers of Rima can now cite another case of a marriage that happened in Rima under this exception, because as we know, what I want to affirm here is that it's an exception.
Before you proceed, let me understand this. Are you suggesting that the protection that is given to a child being defined under African instruments, to which you stated a party, somebody who is under the age of 18 years, are you suggesting that the protection given by these instruments to a child is subject to the consent of a parent or anybody for that matter, that their consent matters and is the essential consideration for purposes of the full protection of the child?
Nestes termos,
In those terms, we would say that exceptionally, that in situations that we can justify, it is necessary for the parents to bring their consent so that their children can, in fact, enter the union of marriage. But the general rule continues to be that in Rima, you can only get married from the age of 18. And in this particular case, we would say that the highest interest of the child here was what was evaluated, and we have taken into context as well the reality and the religion of Rima of each region. So we can actually say that the Republic of Rima is extremely conservative, and that this exception, in fact, occurred was really to protect the child so that these things do not happen. And also that those people did not have protection enough in front of the law, should they in fact want to invoke their rights. That is why my colleague has already said that it's absolutely necessary that those measures, those laws, do not be imposed abruptly in a determined society. It is impossible for us, and administratively speaking, we are taking measures to sensitize, educate our people so that early marriages do not continue. We would like to eliminate these, but we need more time. We need more time to be able to implement that in our state.
Before you proceed through you, Honorable Chair, do these children have any participation in matters concerning getting into these marriages where they have to apply the exception? You've talked at length about the best interests principle. You've talked about the exceptions. Where do we see child participation with regard to these child marriages, where you apply the exception?
As I have already said, the evaluation, whether it is to the best interest of the child is always heard. We always want to know what the child thinks, but the consent of the parents is very important because they have known this child right from the beginning, has always lived with this child, so they are best suited to understand best what the interests of the child are and how they can best be served.
With about 3 minutes. The first one is, you say we have to give you time so that you can change public opinion. What scientific evidence do you have that gives us an indication of how much time it will take for public opinion to change? And then secondly, Council, In the meantime, what happens to children like Mpo, whose hearing hasn't been impaired, who your prosecution refused to appeal the decision of the provincial court, and that's why Mpo is being represented here so that this court could consider. So what happens in between when the prosecution is not taking this matter on appeal, and how long will it take for public opinion to change? Based on what evidence?
I was going to say that given the time needed, I would ask for a reasonable time to be able to sensitize the population, to implement enough measures to educate, because it's not, we can't discuss things here. It's no point considering things here that the people don't believe. We need to sensitize them. We need to say to them that those practices are really harmful because they violate the rights of children. We need them to believe in this so that it can be implemented. If we talk about a reasonable time, it's going to...
I thought earlier you said that the state of Rima is doing everything to protect the rights of the child. Are you now saying it has been doing nothing to sensitize public opinion?
Perhaps if I didn't say this before, Rima has always been committed to human rights, given children's rights even more so, because beyond to have passed a law to protect particularly children, we have laws, for example, where sexual exploitation is concerned, we have a law. Where Mpo is concerned, we cannot really pronounce ourselves.
It's time to stop, but I'm going to give you 30 seconds just to wrap up the role of this international court. This is what you can do. And you say you're asking for time. How much time?
Considering time, we would like reasonable time to be able to implement these measures, because Rima is an underdeveloped state or is a country in development, and that these measures need economic hegemony. We need reasonable time. We would like to leave this to your discretion, Excellencies, so that we have time enough to implement measures to be able to protect Anjij and Mpo.
To have the fourth council representing the respondents, and please take your place.
Dura lex, sed lex. A lei é dura, mas deve ser cumprida.
Law is hard, but it has to be respected. It is with great joy that I greet this court, and I would like to extend all my greetings to my colleagues who are representing the human rights of Rima. And lastly, and no less important, I would like to greet in the name of the state of Rima everybody else, members and participants of this court. States infringe rights that exist, and they never infringe rights that we would like to exist or that we suppose should exist. Honorables, Rima demonstrates that since 1993, which is the date of its independence, that it is concerned with the protection of human rights. And the proof of this, it has ratified several international instruments. If the state of Rima was a state that was blind to issues of the protection of human rights, honorable representatives here of human rights, they would not be present here, because beyond having ratified the African Charter, it has ratified also the protocol which created the African Card, very aware that with this it would give a possibility to NGOs like the one here present, that they would be able to be present here.
While you allude to the fact that REMA has ratified very many international laws, but it has declarations in place that affect the application of those international laws, isn't that a self-defeating process to ratify and have declarations that to its end see that there is no protection of the persons you seek to protect?
The Republic of Rima is not perfect. We would like to say this very clearly, because if it was a perfect state, there wouldn't exist. We've got judicial institutions, we've got police, we've got these. We know that they can have recourse, in fact, to these institutions to have their situation protected. If you decide today in favor of our colleagues, our venerable representatives of human rights, and if you consider their request, as you are saying, that the African court is a first instance court, because it means that we didn't have the possibility at the level of RIMA to be able to discuss totally, or to in fact have exhausted all resources and external of Article 56 of the African Charter. So RIMA is not a perfect state, and it recognizes its faults. And we would like to say that relative to Article 182 and 183, which refer to the lay of criminal sanctions,
of this case, you know about the kind of brutality that the individuals have endured. You made reference to the fact that REMA ratified various international instruments. There are institutions, but I don't know if from the fact that there are institutions and ratified instruments, we go to the conclusion that those ratified instruments are effectively implemented and given effect in the life of people. If that were the case, then we would have, we wouldn't have these cases of brutalities that these individuals have endured. So the question is then, why shouldn't this court consider and indeed give a hearing to these cases? Cases that you are familiar with and that you knew about, but you didn't do anything about.
Tristeza que o venerando possui em relação.
The sadness you feel about these facts, we too feel that sadness, but it was necessary in certain situations to face the competence necessary to resolve this situation. For instance, honorables, the situation of Maria. We say that RIMA failed and violated the rights of women and children internally, but we did report the case to the police. We did do investigations, and when we talk about the death, we concluded it was by drowning. It's not only necessary to have the facts, we have to prove it with proofs, with evidence. We can't say, if we say that Maria or whoever died due to a certain individual, we need evidence. We need concrete evidence to show that she did not die by drowning. And we
you can do. You state that you are committed to protecting the rights of women and stemming out gender-based violence. What is before us is a request that we declare that there's been a violation of the rights of these victims or survivors. But more importantly, what we're being asked to do is to order a renewed investigation and effective remedies. And you yourself are saying evidence is needed. So how do we find evidence? We investigate. Because dead people can't give us evidence, and Maria is dead. And the only people that can investigate are your police, assisted by the prosecution. I don't quite understand why then do object to us taking up the jurisdiction, or us being asked to take up the jurisdiction, and then ordering you to investigate among other things. And ordering you to amend your laws is assisters counsel. I know you've divided the work between yourselves, but since you are the last of the counsel for respondents, we would like to get a clearer picture of what is the theory behind your presentation.
Honorable President of the African Court, to doubt an evidence from the police with mere allegations, we are doubting an institution of REMA. It's not necessary to say only that, yes, Maria died due to the attitude of Rufino without concrete evidence that is going to contest the pericial evidence.
The facts that we have not contested include the fact that there was that WhatsApp message that was sent to Mpo that said, you will have the same fate as your sister from the other side. So that currently the prosecution has attached no weight to that WhatsApp message. So, but that's not the key issue, counsel. The key issue is you haven't, or your prosecution and the police have not investigated. And there's a systemic, there appears to be a systemic problem. And that's why this matter has landed here. So what's your objection to the remedies, the jurisdiction, if you combine that with the remedies that are being prayed for?
Honorable Judge, President of the African Court, to reply to your question, I would like to call your attention to Article 23 of the Constitution of REMA. Article 23 says that any person that alleges that his or her rights were or are or may be violated, or in the case of a person detained or any other person that alleges violation in relation to the detained person without without prejudice to any other action relating to the same issue, that is legally available, that person or that other person may appeal to provincial courts to obtain that recourse. Having proofs and recognizing that the institutions in RIM are not perfect, and with proof that contradict the institution of RIMA, there would be, in the terms of this article, the possibility to come to court instead of going to another court.
But, counsel, the one in this case that has to go to court is your prosecution, because it's a criminal matter, it's not a civil matter. And your prosecution refused to appeal. So what remedy is available then, other than coming to this court to vindicate the rights of the dead Maria?
Veneranda.
Signor Honorable President.
Sir? Okay, 45 seconds.
Sorry.
Honorable President, in fact, we as a state, we say again, and we recognize that our institutions may not be perfect, but in the terms of this article, there is always the possibility of appear before the court to present evidence that was not presented to the court. And with the time that I have left, we would like to ask to make our prayers. Madam President, because we did not have all the resources, we would like to ask this court to consider the applicant's requests, because REMA demonstrates that was always and is concerned with the protection of human rights. We want to say that when we received the communication with this case, we started an inquisition to investigate the difficulties of these institutions in our country. Madam President, in case this court grants us, our representatives of RIMA, if you deign us guilty, we would like to ask for a reasonable period to investigate and resolve the situation, because in RIMA we are different, but we are also equal. Thank you very much.
Thank you, Counsel. I would now ask you to just pause for 2 minutes so that you can stop listening to anybody. And then after 2 minutes of just relaxing, we then get counsel for the applicants to give us a rebuttal. But just 2 minutes of just because we can't go out with. Counsel for rebuttal, just prepare yourself so that you can take a stand as soon as possible. We will now hear counsel for the RIMA Lawyers for Human Rights with your rebuttal arguments. Sir.
Judge President, Honorable Justices, good afternoon once again. My name is Netia, and I intend to make 2 points of rebuttal on behalf of the applicants. with respect to the question of gender-based violence legislation, and secondly, with respect to the question of public opinion. I will turn to the first point of rebuttal. The applicants have made the argument that the Criminal Offences Act is sufficient to protect against gender-based violence in Rema. However, we in fact make the argument that it is insufficient to protect against gender-based violence. To support this, we rely on the CEDAW General Recommendation 35 under paragraph 14, which lists the elements of gender-based violence to be much wider in scope than just rape, battery, and assault. It includes elements such as coercion as well as economical violence, which was suffered by Maria. Should you agree then with the respondents, then it means that this would undermine the mandate of Article 4 of the Maputo Protocol, which requires the respondents to protect against not some, but all forms of gender-based violence. I will then turn to the second point of rebuttal. The respondents have made heavy reliance on public opinion with respect to their international human rights obligations. However, we make reliance on the case of Legal Resources Foundation v. Zambia, 2001, as well as Caleb Orozco versus the Attorney General of Belize, 2017, where both institutions came to the conclusion that popular will or the views of the majority cannot be the sole consideration for a state to limit rights. If you agree with the respondents, then the minorities in Rema would be subjected to a situation or a state of perpetual marginalization. Thank you very much, Honorable Justices. We rest our case.
Thank you, Counsel. This concludes the hearing. The court will now retire and deliberate. Thank you.
All rise.